All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please vous citer. Veuillez vous asseoir.
Good morning again. I would like to welcome everyone in the courtroom. Would the court officer please call out the case?
Good morning, Madam President. This is the situation in the Republic of Kenya in the case of the prosecutor versus Paul Gicheru. Case reference ICC 0109, 0120, and for the record, we are in open session.
Thank you very much. Counsel, can you introduce yourselves, please, starting with the prosecution?
Good morning, Your Honor, and good morning to all. Your Honor, the prosecutor, Karim Khan QC, having recused himself completely from the Kenya situation, it's my honor as Deputy Prosecutor to appear before you to introduce the prosecution team. For the record, my name is James Stewart. I appear with Senior Trial Lawyer Anton Steinberg, Lead Counsel for the prosecution, Trial Lawyer Alice Tsago, Associate Trial Lawyer Inbal Javolowski, and Assistant Legal Officer Mariana Gutierrez. Your Honor, in addition, Associate Trial Lawyer Laura Varlich, who could not be present in court now due to COVID-19 restrictions, will be introduced after the break, and our case manager, Grace Go, is working remotely. Thank you.
Thank you very much, Mr. Prosecutor. The defense team, please.
Good morning, Your Honor. Michael Carnavas for Mr. Gicheru, Lead Counsel. With me is Susanna Tomanovich, Associate Counsel, Noah Elmont, Legal Assistant, and Daria Machete, our case manager. Thank you.
Thank you very much, Mr. Canavas. And for the record, I take note that Mr. Paul Gicheru is in court. Good morning, Mr. Gicheru. Now, for the members of the public, let me quickly introduce myself. My name's Amiata Maria Samba, and I am the judge in this case. As you are aware, we are here today for the opening of the trial of Mr. Paul Gicheru. I'll open with a few preliminary remarks, and then the charges will be read. We then intend to hear opening statements from or by the prosecution. As an introduction, I wish to provide some short background information to this case. On the 31st day of March 2010, Pretrial Chamber 2 granted a request by the prosecutor authorizing an investigation into the situation in the Republic of Kenya. The proceedings before this court is a third active case arising out of that situation. The prosecution alleges that witnesses related to the proceedings of another case emanating from the Kenya situation, in the case the prosecutor against James Samuel Ruto and Joshua Arab Sang, have been influenced pursuant to Article 70 of the Rome Statute. On the 15th day of July 2021, Pretrial Chamber A issued its decision on the confirmation of charges in this case. Therein, it confirmed several instances of alleged interference of witnesses. These are the charges brought before this chamber. In Decision 185, the chamber set a deadline of the 21st day of January 2022 for the filing of any motions requiring resolution prior to the commencement of trial. The chamber notes Rule 1342 of the Rules of Procedure and Evidence. The chamber will now ask the parties whether, save any pending request with the chamber, they have any remaining objections or observations concerning the conduct of proceedings which may have arisen since the confirmation hearings. Now be mindful in accordance with Rule 134(2). No such objection or observation may be raised during the trial proceedings without the leave of the court. I now ask the prosecution.
May it please the court, Your Honours, there are no objections from the prosecution. There is one pending request that the prosecution noted in its trial brief, and that was a request for the chamber to consider legal recharacterization of the charges to the extent of the legal contributions of certain of the alleged intermediaries of the common plan, which the pretrial chamber found did not rise to the level of essential contributions. This is a matter I will address in my opening address, so I'll say nothing further on that at this point. But the matter is already on in our trial brief.
Thank you very much. Mr. Canavas, please.
No objections, Your Honor. We're ready for trial.
Thank you very much, Mr. Canavas. So in accordance with Article 64(8)(a) of the Rome Statute, the charges will now be read to the accused, following which Mr. Gicheru will be afforded an opportunity to make an admission of guilt or to plead not guilty. This is the public redacted version of the charges, in which very limited information is redacted. The chamber notes that Mr. Gicheru and his defense team have access to the unredacted version of the charges. Madam Court Officer, could you please read the confirmed charges?
Thank you, Madam President. The confirmed charges against Paul Gicheru are: first, pursuant to Article 25(3)(a), jointly with another person or as an individual; 25(3)(b), soliciting or inducing; 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0397 by small Roman 1, offering to pay him a bribe of 5 million Kenya shillings in cash installments; small Roman 2, and or threatening him, and or small Roman 3 by actually paying him a total of 1 million Kenya shillings, in order to influence him to withdraw as a prosecution witness and cease cooperation with the ICC, to sign an affidavit to that effect, and or to locate, contact, and or corruptly influence P0516 on behalf of the Common Plan members, committed during the period April 2013 to January 2014 at a redacted location in Kenya. Second, pursuant to Article 25(3)(a), jointly with another person or as an individual; 25(3)(b), soliciting or inducing; 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0516 by offering him to a bribe of 800,000 Kenya shillings in installments and actually paying him a total of 500,000 Kenya shillings, to withdraw as a prosecution witness and to sign an affidavit withdrawing his prior statement to the prosecution, committed during the period of April to May 2013 at a redacted location in Kenya. Third, pursuant to Article 25(3)(a), jointly with another person, or 25(3)(b), soliciting or inducing, or 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0613 by offering to pay her a bribe, the amount of which would be subject to negotiation, to influence her to withdraw as a prosecution witness, committed during the period April to September 2013 at a redacted location in Kenya. Fourth, pursuant to Article 25(3)(a), jointly with another person or as an individual. 25(3)(b), soliciting or inducing. 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0800 by offering to pay him a bribe of between 1,500,000 and 2,500,000 Kenya shillings in order to influence him to withdraw as a prosecution witness, to sign an affidavit to this effect, and to locate and corruptly influence other prosecution witnesses, including P0495 and P0613, committed during the period May 2013 to March 2014 at a redacted location in Kenya. Fifth, pursuant to Article 25(3)(a), jointly with another person. 25(3)(b), soliciting or inducing. 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0495 by offering to pay him a bribe of between 1,500,000 and 2,500,000 Kenya shillings and employment to withdraw as a prosecution witness in the Ruto and Sang case and corruptly influence other prosecution witnesses committed during September 2013 and at a redacted location in Kenya. Sixth, pursuant to Article 25(3)(a), jointly with another person. 25(3)(b), soliciting or inducing. 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0536 by offering her a bribe of between 1,400,000 and 1,600,000 Kenya shillings in exchange for her withdrawal as a prosecution witness committed during the period May to September 2013 and at a redacted location in Kenya. Seventh, pursuant to Article 25(3)(a), jointly with another person or as an individual. 25(3)(b), soliciting or inducing. 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0341 by small Roman 1, offering to pay him a bribe of 5 million Kenya shillings and other financial benefits. Small Roman 2, actually paying him between 1 million and 2 million Kenya shillings. And small Roman 3, intimidating him in order to influence him to refuse to become a prosecution witness if asked to do so, to cease to attend redacted, to sign pre-prepared or dictated affidavits recording his withdrawal from the ICC process and or to locate, contact, and or corruptly influencing other prosecution witnesses committed during the period 24 April 2013 to mid-April 2014 at a redacted location in Kenya. Eighth, pursuant to Article 25(3)(a), jointly with another person or as an individual. 25(3)(b), soliciting or inducing. 25(3)(c) or 25(3)(d) of the statute for the offense set out in Article 71(c) of the statute with respect to P0247 by small Roman 1, promising him at least 2 million Kenya shillings. Small Roman 2, intimidating and threatening him multiple times, including at gunpoint. And small Roman 3, paying him 30,000 Kenya shillings to induce him to withdraw, redacted, to record a false video stating that the ICC attempted to coach him to give evidence against Mr. Ruto, to sign a blank piece of paper, and to locate, contact, and or corruptly influence other prosecution witnesses committed during the period April to May 2012 to 2014 at a redacted location in Kenya.
Thank you very much, Madam Court Officer. Now, can Defense Counsel, Mr. Canavas, can you please confirm that you have explained the nature of the charges to your client, Mr. Gicheru, and his right to make an admission of guilt or plead not guilty to the charges.
Good morning again, Your Honor. Yes, we have fully explained all of his rights, and he intends to go forward with the trial because he maintains his innocence. Thank you.
Well, thank you very much, Mr. Canavas. Mr. Gicheru, can you rise, please? Now, do you understand the nature of the charges read out to you today?
Yes, I do, Madam President.
Do you make an admission of guilt with respect to any of the charges?
Not at all. Madam President, for the record, I plead not guilty. Not guilty.
Respect of all the charges?
Yes.
Thank you very much.
Thank you, Madam President.
You may be seated. We will now turn to the opening statements. The prosecution will commence its opening statement today and have been allotted 1 hour. The prosecution, you may now make your opening statements, please. Thank you very much.
Your Honor, the International Criminal Court was established to end impunity for those responsible for the most serious crimes of concern to the international community. It was established to seek justice for the victims of such crimes. It was established to seek the truth. But in order to establish the truth, victims and witnesses must be able to testify freely and honestly. And when their evidence is perverted through corruption or intimidation, the truth is obscured and justice is denied. The prosecution brings this case against Paul Gicheru to protect the integrity of the court's proceedings from offenses against the administration of justice, to punish those responsible, and deter future offenders. We seek to preserve and strengthen public confidence in the court and the expectations of those who look to the court to establish the truth and deliver justice. Those who would seek to undermine the court's ability to provide redress for the victims of mass atrocities cannot be allowed to prevail. They must be held accountable. Your Honor, the investigation and prosecution of William Samoei Ruto and Joshua Arap Sang was beset from the outset with witness interference and intimidation problems, which continued up to and throughout the trial. In dismissing the charges against those two accused, the judges in both the majority and minority opinions of the trial chamber condemned the levels of witness interference, which had made it impossible for the chamber to ascertain the truth. The most egregious and damaging instance of such witness interference, with the accused, Paul Gicheru, allegedly at its center, commenced in early 2013 and continued throughout the trial. This interference caused the Office of the Prosecutor to start an investigation in parallel with the Ruto and Sang trial into numerous reports of witness tampering. That investigation allowed the prosecution to uncover and document the commission of the offenses that formed the basis of the case that is now before this chamber. The evidence gathered in the investigation will show that the accused managed and coordinated a scheme to identify, locate, and corruptly influence actual and potential prosecution witnesses. This was done through a combination of bribery and intimidation. The actions of the accused and his associates led directly to the withdrawal and recanting of no less than 4 vital prosecution witnesses in the Ruto and Sang case. The efforts of the accused and his associates to influence corruptly a further 2 witnesses were only thwarted because the witnesses they targeted reported this to the prosecution. while the prosecution does not allege that the accused was himself directly involved in the disappearance and presumed death of another prosecution witness, or in the murder of a prospective defense witness and a former prosecution intermediary, Meshach Yabe, both of these individuals, as the narrative of the case will show, were caught up in the witness tampering scheme. The accused and his associates may not have been the only persons responsible for witness intimidation and tampering in the Ruto and Sang case. However, the evidence will establish, beyond a reasonable doubt, that they were responsible for the offenses charged in this case. This trial, therefore, represents an important step towards holding those responsible for witness interference in the Kenya cases accountable for their actions and achieving some measure of retribution on behalf of the victims who were denied justice. The prosecution notes that 2 further suspects for whom arrest warrants have been issued for the same offenses remain at large, and we call upon the Kenyan authorities to take all necessary steps to surrender these 2 suspects to the court without further delay. Your Honor, I yield the floor now to senior trial lawyer Anton Steinberg and the prosecution team, who will outline in detail the case that the prosecution will present to establish the guilt of Paul Gicheru.
Good morning again, Madam President. May it please the Court. The prosecution will now outline how it intends to prove the charges that have been confirmed against the accused. I will present a general overview of the prosecution case and how it will prove each of the 8 confirmed charges. My colleague, Ms. Zago, will then outline the evidence that will be presented on the accused's individual criminal responsibility. The prosecution does not propose to address in detail the offences charged, which are fully explained in the document containing the charges and have just been read out by the court officer, although I will briefly summarize these for the benefit of the watching public. Nor do I propose to repeat the legal arguments that are advanced in the prosecution's trial brief. Rather, we will focus on the evidence that will be presented and how this will demonstrate, beyond a reasonable doubt, that the accused committed the charged offences and his criminal responsibility. As confirmed by the pretrial chamber, the accused is charged with 8 counts of corruptly influencing prosecution witnesses in the Ruto and Sang case in contravention of Article 71C of the Rome Statute. This was done through a wide-ranging and concerted scheme of witness interference over the course of almost 2.5 years. The accused bears criminal responsibility under several possible modes of liability: direct, indirect, and accessory. In this opening address, the prosecution will focus on the accused's criminal liability by way of his direct and personal perpetration of acts of corrupt influence, as well as his essential contributions to a common plan to do so. The common plan confirmed by the pretrial chamber encompassed the identification, location, and contacting of prosecution witnesses and potential prosecution witnesses in the Ruto and Sang case, offering and paying them financial benefits, and threatening or intimidating them, all to induce them to withdraw as prosecution witnesses in that case, to refuse to cooperate or to cease cooperation with the ICC, and to recant the evidence which they had provided to the prosecution. The common plan group comprised of a number of persons who undertook specific roles. Some, including the accused, fulfilled the role of managers, who organized the activities of other Common Plan members, arranged financing, and negotiated bribe amounts with witnesses who were corruptly influenced. Intermediaries were responsible for locating and contacting witnesses and persuading them to meet with the Common Plan managers, to be bribed or intimidated. And still others, while not confirmed as members of the Common Plan, were associated with it and made contributions to the commission of at least one offence charged. And as I noted earlier, Your Honour, the prosecution notes in this regard that it has provided submissions in its trial brief that the pre-trial chamber, with respect, mischaracterized the contributions of certain of these associates and invited the trial chamber to exercise its power to legally recharacterize these contributions as essential and to give the defence notice of this possibility pursuant to Regulation 55.2. In fairness to the defence, the earlier this notice is given, the better it would be for them. I will now briefly touch upon some of the main types of evidence that the prosecution will present in support of these 8 counts. I will also provide some snippets of this evidence demonstrating how offences were committed and the role played by the accused in their commission. I am conscious, Your Honour, that we are in public session, and I have applied the necessary redactions to these extracts. I will also not read out the ERNs which are reflected on the extracts, and I can provide a copy of this presentation to the Chamber and parties immediately afterwards. Starting with count 1. Since witness 397 is unavailable to testify, the Chamber has granted the prosecution's request to submit into the record his prior recorded testimony. This evidence demonstrates how he was corruptly influenced and recruited by Common Plan intermediaries Yabay and Bet. He explains as follows. Yabay and Bet act like brokers. They identify witnesses and tell that group, and then they facilitate by giving of money, and they also receive their own remuneration. The evidence further demonstrates how he was taken to meet managers Gicheru, the accused, and Samatwo, and relates the events as follows. Starting at line 82, and I quote, "And he told me," he being the accused, "and he told me that they'd received a report that I was a witness. And he told me that if that was the case, they asked for my support for me to withdraw from the case." And he quotes, "Honourable Ruto really requests that you try to bring in any witnesses that you know, and then we'll give them something." From line 105. "So I asked him, what do they offer if I withdraw from the court, from the case? And he asked me, why don't you yourself speak? And I told him I wanted 10 million Kenyan shillings. Then we locked horns over it, and he sweet-talked me and so forth, until we arrived at 5 million. He promised me that he would pay me in installments. That month, they paid me 1 million. They gave me 600,000 first, and then later on he gave me 400,000. So that was 1 million. And throughout that quote, the he being referred to is the accused. P397 further details how he was instructed in turn to recruit witness P516 to be bribed, to which I will return under count 2. The prosecution will present the following corroboration for the prior recorded testimony of P397. Starting with bank records. The bank records will confirm that the witness deposited 2 large sums of money into his bank accounts on dates corresponding with the dates on which he says he received payments from the accused. Firstly, on the 27th of April 2013, he deposited an amount of 500,000 Kenyan shillings, having explained that he spent the other 100,000. And 3 days later, on the 30th of April, he deposited a further 400,000 Kenyan shillings, bringing his bank balance to just shy of 900,000 Kenyan shillings. Prior to these deposits, the balance on this account was 297 shillings. Phone records will confirm these two deposits as they reflect text messages from the bank confirming these two deposits. Phone records will also corroborate his contact with the accused, whose phone number was recorded in the witness's contact list. The number reflected in the contact list corresponds with numbers that may be found on the accused's business cards and letterheads. We will also produce a letter of withdrawal sent to the prosecution by the lawyer to whom he, the witness, was referred by the accused. We will prove recorded calls between the witness and the accused, and also with common plan intermediary Yabe, the contents of which we say are inconsistent with innocence. And we will present the testimony of other witnesses, including P516, P613, and P341, who will provide corroboration for the version of P397. P516 will confirm that P397 took him to meet the accused, who paid him. P613 will confirm receiving reports from another common plan intermediary, P579, that he, that is 397, was paid 500,000 Kenyan shillings by the accused. And P341 will provide the following evidence. I also saw P397 and P516 at Gicheru's office many times. I spoke with both of them, and they had told me that they both received money, but they both had told me that if they did not receive all their money, they will return to the ICC. I move on to count 2. The prosecution will present the evidence of P516, who will testify that P397 took him to meet Gicheru, as I mentioned a moment ago. He says the following from line 285. Yeah, so what happened when I met up with P397 was that he phoned and then I had a meeting with him at a hotel. We met and he told me that the next day we were supposed to go and meet a person called Paul Gicheru. The interviewer asks, okay, and for what purpose? He replies, he told me that Gicheru was giving out money. The interviewer asks, okay, and why was Gicheru giving out money? The response, P397 said it was money for witnesses. When P516 met with the accused, the latter offered and subsequently paid him money. Evidence reflects as follows. Tell us about that discussion about money. The witness says, yeah, I spoke to him, him being the accused. We agreed, give me 800,000. But he didn't give me everything, he gave me 500. Moving on to the corroboration for the evidence of P516. The prosecution will also present the following corroboration, starting with the prior recorded testimony of P397. I quote from line 593, I beg your pardon, 594. So I heard Gicheru telling Meshach Yabe, you'll go and look for him. Meshach told him, no, I think he sometimes speaks to 397. Perhaps. Then later on, Meshach told me, you do this. Go and talk to him. I just went to P516 to find out if he really was a witness, or whether it was propaganda. And carrying on from line 600. I found out that he really was a witness. So I brought him in. I told Gicheru to talk to this person. I went out and they talked. From line 814. Afterwards he told me, when we met, he told me that he'd been promised that on a certain day he could go and collect money, and I think he really did go and collect it later on. The interviewer asks, okay, did he tell you how much it was? And he responds, I think P516 got around 500,000 or 800,000 shillings. I've already mentioned the evidence of P341, that he saw both of the witnesses at Gicheru's offices. And I've also mentioned the report from Common Plan Intermediary P579 to P613, confirming that Gicheru paid a number of witnesses, including both P397 and P516. I move on then to count 3. In this count, the prosecution will present the evidence of P613. She will testify that she was approached by Yabe and at least 6 other Common Plan intermediaries and associates on separate occasions. This included approaches by Common Plan intermediary P579, which he describes as follows. P579 told me to tell them how much I want. P579 was told to come to Kampala with a phone so we could meet and I could talk to those people over the phone. He was given instructions, P579 was given instructions from Gicheru to go to Kampala with the phone. P579 told me that this group are fearing me and that is why they are doing this with the phone, because they are not trusting me and think I will report it to those people who I knew to mean the ICC. She was also approached by a former prosecution witness and Common Plan associate P495. She describes this as follows. P495 told me that Gicheru has been given all the authority. P495 told me when you are given money, they have offered protection because they don't want you going back to the ICC. I asked P495, so it says is to Gicheru, I think it means, should read is it Gicheru. So is it Gicheru who is going to finish this thing with us? And P495 replied, yes, they want to meet with us tomorrow. Moving on to corroboration. The prosecution will present recorded conversations with both Common Plan intermediaries P540 and P579. I start with the latter, who told her the following. P579. No, these people have a network. Then there's unintelligible words, and he carries on. They have a chain of command. P613. Oh, a chain of command. P579. Now, I have been shown how it works. If they want to call you, then this one will call the other, and then the next, until it gets to you, just like that. From line 106. For people like you who are far away, then you will have to come to Nairobi. P613. To be given cash. P579. You will need to talk first and discuss until you agree. And then again from line 112, P579. You will be given clean cash, P613, and you will be told never to put it in a bank account, which he confirms. Then there's a recorded conversation with the former witness and Common Plan associate P495, who speaks about how he told the accused that he will go and come with that lady, referring to P613, after which he would take his share. P613 asks him, who is in charge? And from line 122, he's in Eldoret. He's the one who is giving it out. P613, is Gicheru the one giving it out? P495, yes. P613, who is he with? P495, I don't know. I was not told the next one. P613, is he with the one who was CDF chairman or Simatwo? P495, there is one who is superior and I wasn't told who that is. I was told it is not necessary to know that much. You will be sorted out here. I move on to count 4. The prosecution will call the evidence of P800, who will in fact testify immediately after the next break. The witness will testify that he was approached by Common Plan intermediaries P540 and P579. He describes the approach from P540 as follows. P540 then told me that the big man offered 1.5 million Kenyan shillings and additional expenses to join the big man's team and withdraw his assistance to the ICC against the big man. Paragraph 29. P540 then asked me to accept the same offer of 1.5 million Kenyan shillings, which had been approved by the big man, on condition that I withdraw myself as an ICC witness. And I digress to state that the witness also clarified that he and P540 used to refer to William Ruto as the big man. He carries on at paragraph 45, saying the following. P540 told me that the money to pay me and the others was coming from Ruto, and the money would be coming via Eldoret lawyer Gicheru. P540 told me that Gicheru Simatwo, who I think is in charge of Amaco Insurance, which I think is owned by Ruto, and ex-ambassador Stephen Taras are all working for Ruto trying to locate Kenyan witnesses. P540 told me he is working for Gicheru, who is trying to locate witnesses within Kenya and nearby countries. I note for the record that it says tring. I think the Y is missing. It should be trying. The witness will also testify that P579 subsequently took him to meet the accused. P579 introduced me to the people who were sending him to get me. This is the person named Gicheru. He's a lawyer, and he's the one who was actually sending P579 to get me. From line 67. This is where he also pledged to give me an offer to get 2 million Kenyan shillings. I was given the opportunity to make sure that I get back those people that I have introduced to the ICC. I won't say more than that in public session. Turning to corroboration, the prosecution will provide the following corroboration: recorded conversations with both P540 and P495. Common Plan intermediary P540 speaks about the fact that many prosecution witnesses were leaving and stresses the importance of Ruto's case ending, that it should end quickly in the middle. He also confirms that the accused is the one giving out the money, stating in part as follows. Gicheru is handling those things. He's liaising with Simatwa and Ruto. He's handling those things. You know, my friend, many people are going back, my friend. Now it's that side of Ruto that shouldn't go to the media, to the public. We will also submit P800's withdrawal affidavit and a supporting affidavit in Barassa's High Court challenge to his ICC arrest warrant as proof that he had been corrupted by the Common Plan group. I turn then to count 5. The prosecution alleges that P495 accepted a bribe from the accused and thereafter himself attempted to recruit P613. He subsequently withdrew as a prosecution witness and was summoned to testify in the Ruto and Sang case, where he recanted his prior testimony and claimed to have been coached by P613 to give false evidence against Mr. Ruto. Although P495 is still uncooperative, there is ample other evidence to establish that he was corruptly influenced by the accused and his associates. Starting with the evidence of P800, we will describe that P495 was brought to a meeting with the accused in Nakuru, at which he, P495, was promised 1.5 million Kenyan shillings and was also given the task of recruiting P613. I refer, Your Honour, to Ken OTP 0135-0103 at 0106. I'll repeat that slowly. Ken OTP 0135-0103 at 0106, which I will not display in public session. P800 will also describe conversations he had with P495 after the latter was summoned to testify via video link from Nairobi, from line 431. So P495 was very open, and he told me that, don't worry, arrangements are done. People meet these guys, 10 of them, led by Gicheru, and you are able to be told what you are going to say. So it's not a big deal going to video link, as long as you follow what the advice of the lawyers. And from line 454. But actually P495 told me that they have decided to put all the blame on P613. All the blames, according to 495, on who recruited the witnesses, who told them what they're going to say to investigators of the Office of the Prosecutor. All that was said to be cooked up by P613 and imposed on them so that they could go and become witnesses. So according to P495, they had decided that they are going to blame those people that were known and actually who had refused to go back. And actually P613, he mentioned P613 as one of those. Then there's the evidence of P613 herself. She describes a conversation with P495, who told her that he had been promised 2.5 million Kenyan shillings, as well as a job. I read from paragraph 76. P495 stated along with the money he was also offered a job. P495 told them, I don't want to take any money until P613 is there, at the meeting with the lawyers. P495 told them he has accepted their offer. She was also told that the accused was the one giving out the money. I asked who was in charge, and P495 told me that these people are two, meaning the people we are to meet. P495 told me Gicheru is the one that gives out the money, but he did not mention the name of the other person because he told me he does not know the name of the second person. As regards corroboration, the evidence of both these witnesses is corroborated by the recorded conversations with P495. I've already referred to the recorded conversation between P613 and under count 3. But P495 also confirmed to P800 in a recorded conversation that he had met with P613. I won't say any more in public session. Moving on to count 6. Again, mindful we're in public session. The prosecution will present witness evidence corroborated by recorded conversations that Common Plan intermediary P540 offered a prosecution witness a bribe of 1.4 million Kenyan shillings if the witness withdrew and returned to Kenya to meet with the accused, who P495 described as follows. He's Kikuyu. He's, do you know Gicheru? He's the one doing that job. And he's the one who finalizes things with all those people who are coming to this side, the people who are returning, unquote. Count 7. In this count, the prosecution will leave the evidence of P341. He will testify that he was taken by a Common Plan associate to meet with the accused. That same day, I met with the Common Plan associate in Eldoret, and he took me directly to VCAM House, which was the office of lawyer Paul Gicheru. I then attended his office on about the 3rd floor. During the meeting, Gicheru, another Common Plan manager, and the Common Plan associate asked me questions about whether I was an ICC witness, and it appeared they did not know if I was a witness or not. I told them I was a victim and not a witness. They all discussed with me that I should not go to the ICC meetings any further and should not become a witness if I am asked by the ICC. They all appeared concerned that while many people were withdrawing from the ICC, there were a lot of new ICC witnesses coming forward, which appeared to be a problem for them. Paragraph 49. In the same meeting, the Common Plan associate told me if I agreed not to go to any more ICC meetings, they will help me and I would be given a car, another farm, a plot in town. My children will be supported in their schooling, and those leaving school would get jobs in government, and I would also receive 5 million Kenyan shillings. The Common Plan associate asked if I would agree to this, and I said yes. I agreed as I was very intimidated, and they had gone to a lot of effort to approach me. From paragraph 50. During the meeting, the Common Plan associate, the Common Plan manager, and Gicheru were all telling me that I should approach many witnesses inside and outside the country and convince them to withdraw from the case, as they knew I know many witnesses. The witness will also testify about the payments he received from the accused. The first payment of 500,000 rand was paid on the, 500,000 Kenyan shillings was paid on the 2nd of May 2013. Thereafter, several further payments totaling approximately 2 million Kenyan shillings in all. From paragraph 63. Gicheru then opened a drawer attached to his desk and handed me 500,000 Kenyan shillings in 1,000 Kenyan shilling denominations, held together with an elastic band. A bit further on, Gicheru told me not to deposit the money in the bank and told me that I would have to return later to sign an affidavit. Gicheru had previously told me the ICC can inspect the records at the bank if I deposited the money. Notwithstanding this warning, the witness did in fact deposit a significant portion of the money he received from the accused in his bank account, which the ICC did indeed trace. Over a period of approximately a year, the witness deposited a sum of 1 million Kenyan shillings into his bank account, as is reflected by the bank records that he provided to the court. There are also phone records. The witness will testify that Gicheru told me not to call the office, and Gicheru entered his number in my phone, and he gives the number which I've redacted, which Gicheru saved on my phone as Paulo. And indeed, there is a contact, Paulo, on the accused's contact list under the same number that appears on 397's phone records, as well as the business cards and letterheads of the accused. Furthermore, the evidence of P274 will corroborate the corruption of P341 by the accused. P274 received the following contemporaneous report from the witness. P341 told me that he had met a lawyer called Paul Gicheru, who gave him some money so that he would stop providing information against the ICC, so that he would stop providing information to the ICC against William Ruto, and he would be left in peace. He told me that he had already received 500,000 Kenyan shillings from Gicheru. His clothes were more expensive, and he paid for lunch, so I could see that he had more money than usual. Finally, I turn to count 8. On this count, the prosecution will call the evidence of P274, who I've just mentioned, who will testify that he was taken to meet the accused where the following transpired. Quote, Gicheru said that they, meaning he and others, preferred to pay these people so that they would stop assisting the ICC. He said that they needed to reach everyone involved in this case, indirect or direct. He said the big man, Mkubwa, wanted no stone left unturned. I assumed by the big man he meant Ruto, since the case was about him, and he would be the one who wanted the case to stop. Gicheru said that he was offering me the same amount as P341, so that I could withdraw and stop dealing with the ICC. He told me he would give me 500,000 Kenyan shillings first and another 500,000 Kenyan shillings later. He also told me that I would now be safe. He also wanted me to give him details of other people I knew who were witnesses or victims in the ICC case. As regards corroboration, P341 confirms that the accused was looking to recruit P274. During the meeting, they, including the accused, told me to locate my friend P274 to meet with Gicheru and sign an affidavit to withdraw from the ICC. Your Honours, besides the direct evidence on the 8 counts, the prosecution will also call another witness, P743, who will confirm that he too was paid by the accused to withdraw from the Ruto and Sang case, following the same modus operandi. And apart from the individual proof of the commission of each counts, there is the cumulative effect of the evidence, Your Honours, which demonstrates a consistent pattern of behaviour by the accused and his associates for a consistent purpose: to locate, contact, and bribe or intimidate prosecution witnesses to withdraw and recant their evidence. The prosecution will also tender a number of other documents, including phone records and transcripts of an interview with the accused in which he made certain admissions. In fact, that has already been admitted. The prosecution will argue that this evidence establishes individually and cumulatively the commission of each of the 8 counts charged beyond reasonable doubt. May it please the Court, Your Honour, I yield the floor now to my colleague, Ms. Zaga.
Thank you, Mr. Steinberg.
Your Honor, the evidence the prosecution will present show that while the Ruto and Sang case was proceeding to trial in 2012, back in Kenya, the accused, together with others, carried out a plan designed to fatally compromise the prosecution's evidence in the trial by preventing witnesses from testifying or coercing them to recant their evidence on the stand. In so doing, the accused interfered with the course of justice and committed the offenses charged. In the next 10 minutes, I will set out the key evidence the prosecution says establishes the individual criminal responsibility of the accused as a direct co-perpetrator. However, as submitted by the prosecution in the document containing the charges and subsequently in the prosecution trial brief, and as briefly mentioned by Mr. Steinberg before, the accused conduct can also be legally characterized under different modes of liability. But let me turn now to the accused culpability as a direct co-perpetrator. Your Honor, you will hear and read evidence in this trial about the common plan the accused devised with the assistance and participation of others. The same witnesses who were contacted and targeted by the accused and these other individuals will testify when and how the plan was set in motion and how it operated to achieve the set objectives. These witnesses will identify the individuals who corrupted them, and describe their respective roles and responsibilities in the execution of the plan, which, as Mr. Steinberg mentioned before, included managers, intermediaries, and other type of associates. But as I said, I will focus today on the accused, on how he participated in this plan, what role he had, and what contributions he made to its implementation. Testimonial evidence will show that he was essential in directing and coordinating the activities of the members of the plan. You will hear and read first from the witnesses targeted. Their evidence proves on its own the accused's criminal responsibility in this case. However, witness evidence will not be the only evidence you will hear, Your Honor. You will see bank statements showing large deposits of money on witnesses' bank accounts right after having been bribed. You will also see phone data records, as well as audio recorded conversations between witnesses and members of the common plan, including the accused, showing witnesses were being approached and unduly influenced. In all, the evidence will show that Mr. Gicheru played the key role of a manager. From his office in Eldoret, the accused leveraged his influence as a prominent member of the community and of the legal profession. He decided which witnesses should be targeted and how much money or other benefits these witnesses should be offered in exchange for ceasing all cooperation with the court. In this respect, a witness will say that the accused told him that he has received the task of locating ICC witnesses and giving them money, and that I had received that task from Mr. Ruto. Testimonial evidence will also show that the accused ensured that the necessary funds were made available to pay witnesses in exchange for their withdrawal or recantation. The accused assigned tasks to other members of the common plan, such as locating and contacting witnesses inside and outside Kenya, offering them money or other benefits, and bringing them to meet Mr. Gicheru in his office or elsewhere in the vicinity. Other testimonial and documentary evidence will show that the accused directed and arranged for witnesses to sign legal papers to cease cooperation with the court. Similar evidence will also show that the accused met with witnesses himself, negotiating and paying them money. A witness will testify that the accused paid him no less than 1 million Kenya shillings, almost 12,000 US dollars at the time, when, according to public records, the annual income per capita in Kenya was approximately 1,000 US dollars. The same witness will say that the accused told him on repeated occasions not to get involved with the ICC, refused to testify, and refused to give any information to the ICC regarding Mr. Ruto. Witnesses will say that when they met Gicheru and other members of the common plan, they felt pressure into complying with their demands. In one of such meetings, a witness will say he could not reject the money paid to him by the accused because doing so would mean he was disagreeing, and this would immediately place him, the witness, and his family in danger. You will also read from another witness who is not available to testify that Mr. Gicheru accused him of being still cooperating with the ICC and of wanting to have Ruto arrested by the ICC. At that meeting, Mr. Gicheru had to be calmed down by one of his associates, and the witness left feeling fearful for his life. All testimonial and documentary evidence the prosecution will present show that the accused's contributions to the common plan were essential, and that without them, the offenses he is charged with would not have occurred or would have occurred in a significantly different manner. This evidence, Your Honor, will show that the accused's actions were deliberate and designed to pervert the course of justice in the Ruto and San case. It will show that the accused meant to engage in his conduct. As an experienced member of the Kenya Bar, there can be no doubt that the accused was aware that the common plan had a criminal component, or that the implementation of this plan was virtually certain to result in the commission of the offenses. In this respect, a witness will say that Mr. Gicheru told him he knew ICC people were investigating him, and he knew he could go to prison. Similarly, other testimonial evidence will show that a witness was told not to deposit the money he received from the accused in the bank because, and I quote, "These ICC people have devices to follow up with banks, and they will see the money," end of quote. Further evidence will show that the accused was also aware that his role in the implementation of the plan was essential, and that he knew that due to the essential nature of his contribution, he could have frustrated the implementation of this plan. He could have impeded it, he could have reported it, and above all, he could have simply declined to engage in it. In sum, Your Honor, the evidence the prosecution will present in this trial will show that the accused, together with others, worked in unison to identify and locate witnesses, to contact them to offer and provide financial and other benefits, all in order to induce them to withdraw as witnesses, to recant their evidence, or cease and refuse to cooperate with the court in the Ruto and San case. Your Honor, with this conduct, the accused engaged in the commission of the offenses charged, and he did so with the required intent and knowledge. Your Honor, the evidence in this case will show beyond any reasonable doubt that Mr. Gicheru is criminally responsible for all of the Article 70 offenses against the administration of justice for which he was committed to trial. Thank you, Your Honor. This concludes the prosecution's opening remarks.
Thank you very much. Well, thanks to the prosecution team. So we have now reached the end of the opening statements by the prosecution. We will resume the next session at 11:30 with the beginning of the presentation of evidence by the prosecution and the questioning of the first witness.
Your Honor,
Sorry.
I apologize. Your Honor, I understand that the defense is not going to make an opening statement at this time. With your permission, I ask to be allowed to withdraw my presence and, of course, to leave the case with Mr. Steinberg.
Surely.
Thank
you
you.
may do
Thank
so.
you,
Thank you very much. Yes.
All rise. Veuillez vous lever.